Good evening. My name is Chuck Allett. I am the Executive Director of the Aquidneck Land Trust, and this is a workshop on Citizen Planning 101. Thank you for coming tonight. So these workshops are a collaboration between ALT and GrowSmart Rhode Island. There will be one for each of the three communities, and then we will have an advanced program on October 20th that will be open to everyone on the island. The one thing I wanted to note is that in some of the materials, the September meeting, which is actually a meeting for Portsmouth, was set as September 28th. It's actually September 29th, 2021. So in 2019, in an attempt to create a compelling argument for open space protection, why conserve land, why now, ALT retained a planning firm, Sasaki and Associates, to help us in preparing a development impact analysis. That analysis took over 8 months to prepare, and what it was intended to do is to determine what Aquidneck Island would look like in 30 years under two scenarios. The first, if we did nothing to change our land use patterns at all, we kept doing things the same way we were doing them. And the second was if we changed it up and used more innovative mixed use zoning as a way of developing some property in the future, but not all. And I think the results were quite startling from that report. Alex Schuman, ALT Stewardship Director, will get into a little bit more detail on those in just a second. But the one thing that came to mind to me is from a 30,000 foot approach, it was very interesting how communities, when they talk about how they want to see their community in the future through their comprehensive community plan, and what they say that they want to preserve open space and conserve farming. But when you look at the zoning that's currently in place, and if you were to build out based on the existing zoning, the build out is not going to accomplish what residents have said they want in the comprehensive community plan. And that's not unusual. In Middletown, it happens in many communities that the zoning just it's inconsistent with the comprehensive plan in many ways. And I have to say that Middletown has done a really good job in trying to create consistency between their comprehensive community plan and their zoning. But even with that being said, there are still a lot of inconsistencies. One example is that in the comprehensive community plan, there's a clear goal to protect farmland and farmland soils, yet over 75% of the farmland on this island is zoned for residential development. So that's a clear case of where there's an inconsistency between what people on the ground are looking for and what the zoning build out will actually accomplish. In November of 2019, we did a rollout of this development impact analysis. And there were a lot of people there, like 120 people showed up for that. And what was a recurring theme is residents wanted to know what could they do to make the community the way they wanted to see it. And so that's kind of the genesis of these workshops. What we're trying to do is get people more engaged in land use planning in their own community. And we think before they can do that, it's important to kind of know how the process works. Many people object to zoning requests that are near their property, but what we don't see is a lot of people actually engaging in the process of changing the ordinances so that we see on the ground what we want to see in our comprehensive community plan. And so that's really what these workshops are about. Now, while in the report, there is an essential bias towards working on innovative land use zoning, there's no bias in these workshops whatsoever. Whatever people believe should be done, we just want people to be more engaged in the process and express their opinions and be able to express their opinions on land use that's changing their community on a daily basis. So at this point, I'd like Alex Schuman, our ALT Stewardship Director, to just give an outline of the summary of what came from that report.
Great. Scott, were you going to say a few words next, or do you want me to?
I can, or I can delay, whatever.
I'm sorry,
whatever you
Scott,
folks
why
prefer.
don't you do that at this point? I apologize.
No problem at all. So thanks, Chuck, for your leadership on setting a good sustainable course for this beautiful place that 70,000 or so people call home, and that millions of people visit. I'm Scott Wolfe. I'm Executive Director of GrowSmart Rhode Island, and I'm looking forward to tonight's session and the other 3 in the series. We're particularly enthusiastic about this series because with all the disruption in our lives and in the lives of our communities over the last year and a half, I think it's very timely that we take a fresh look at the future well-being of our communities. And I think the main focus overall of this series, and Chuck outlined it very well, is how can we all ensure the future environmental and economic well-being of this outstanding place. So in addition to helping to set the stage for tonight's workshop, I want to introduce you briefly to GrowSmart Rhode Island. We're a nonprofit policy, research, advocacy, and land use training organization. And we're committed to making Rhode Island a place where every person benefits from vibrant neighborhoods and downtowns, from restored and protected natural resources, and from a just, thriving, and resilient economy. And one of the major ways we pursue these critical goals is through our community land use training program, which has been around in some form for most of our 23 years of existence. And the program has relied on exceptional volunteer land use professionals to deliver its workshops. And tonight's is the latest example of that, thanks to the dynamic duo of Ashley Sweet and Caroline Wells, whom I'll tell you a little bit more about in just a minute or two. Our land use training program has 2 major components. One is what I call basic training for local elected and appointed government officials and how to handle their land use decision-making responsibilities as effectively as possible. And the other component is more specialized training for not only these folks, but for concerned community residents and other interested parties on specific smart growth tools to encourage well-planned pedestrian and transit-friendly development in built-up areas, along with conservation of our key natural resources. The run of the show tonight is that you're going to hear in a few minutes from Alex about this groundbreaking report that ALT did several year and a half ago or so, and then you'll hear from our faculty, in a sense, Carolyn Wells and Ashley Sweet. And after their presentation, there'll be about a 20-minute opportunity for those of you in the audience to pose questions and offer comments. We plan to adjourn around 7 o'clock. As far as some logistics, we're asking you to put your questions and comments in the Q&A section of the Zoom platform here. When we get to the actual Q&A session, you can also raise your hand. So with that, it's my pleasure to turn things back over to Alex and thank everybody in the audience and thank ALT for this opportunity to move the needle in a positive direction in a special part of Rhode Island and America. All yours, Alex. Oh, and then I guess I will introduce Caroline and Ashley in a little more detail when you're done, Alex. How's that?
Great. I just wanted to, can everyone see the presentation?
Yes.
Okay, great. Great. So Chuck gave a little bit of the backdrop on our development impact analysis. And really, what I'm going to do is just touch at sort of a bird's eye level on the report. It's a very comprehensive report. I'll put a link in the chat of it at the end of the talk, but we'll just do like a 10 to 15 minute summary of the analysis and some of the key findings. The report really goes into detail very transparently on the methods and all the findings. So I would encourage folks to take a look at that as well if you're curious and have questions after this, or feel free to put questions in the Q&A as well. So as Chuck mentioned, we worked with Sasaki & Associates, which is a large firm out of Boston that specializes in land use work. And the goal of this analysis was to understand the potential impacts of future development on Aquidneck Island, very simply. And again, as Chuck mentioned, we basically looked at two different scenarios for the future of the island. The first was if trends continue, basically status quo. And the second would be what if the island had a different path where we really prioritize conservation. And while development pressure still existed, we looked at it and redirected it in a different way. And we called these scenario 1 trends continue and scenario 2 plan and protect. So I'll frequently refer to those two scenarios over the next 10 minutes or so. And the analysis basically started with modeling out each scenario across the landscape, parcel by parcel. So we saw how the island would be built out over the 30-year period to 2050. We then were able to visualize at the parcel level into a series of maps and renderings what that might look like on the island. Once we had that information, we basically looked at the impacts of what the development patterns in each of these scenarios would have on the island. And then we were able to draw out some key findings. So I'll just touch on these again fairly briefly over the next few minutes. So one of the really important things to note, and this has come up a lot, but as most of us probably know, the population of Aquidneck Island has stayed pretty flat since really 1980. You can see from the graph on the left here, sort of around 60,000 people. And even though that's the case, we still see construction and more units built with each year. So you can see on the right, the purple line is Aquidneck Island. We've averaged around 165 units built per year since 1980 to 2017, I should say. And that's around 6,200 units. Why is that the case? For a few reasons. Most likely, the first and probably most obvious is we obviously have a robust second home market here on the island. And just anecdotally, that seems to be spreading from not just coastal areas, but really throughout the whole island. There's, of course, Airbnbs more recently. And then just as a general trend, since 1980, household size has decreased as well, which, you know, if you have smaller household sizes, you need more houses physically to keep up the same population. So it's a combination of all those factors, most likely. The key point here in terms of our analysis is that we use that rate of 165 units per year to inform what the development would be demand would be moving forward over the 30-year period. So in both scenarios that I'll talk about, we were looking at 5,000 new units over 30 years. And of course, that might get more aggressive. Certainly the last couple of years we've seen with the COVID pandemic, a lot more demand for development here on the island. But we use that rate of 165 per year for this analysis. So the first step, and this is a bird's eye view if folks are good with maps and aerials, looking north up West Main. We gathered all existing conditions on the island, put together a really comprehensive land use layer, for all of Aquidneck Island and zoning layer as well. Just some of the key findings on this phase was, as Chuck mentioned, almost 80% of the remaining unprotected open space on Aquidneck Island is zoned residential and medium density or low density residential at that. And that's true in Middletown as well. Middletown's around 75%. About half the open space on Aquidneck Island as well is protected and half is subject to development. So once we had those existing conditions, we started building the model for the status quo scenario and what a build out would look like. And this was basically going from existing zoning and looking at constraints across the landscape. So of course we didn't allow building to occur in wetlands, for example. But when you look parcel by parcel and you look at the zoning on parcels, you can kind of estimate what the density might be as those are built out. So what we found, and you can see here, sort of the red structures here on new developable land. We actually, over the 30-year period, ran out of open space according to demand. So there, the island got built out so much by 2050, there was no more open space left other than what had been protected. And so typically in this scenario, you would see, as we've seen over the years, you know, farmlands like this just being built by right, you know, residential subdivisions, you know, typical views we would see with by right these types of subdivisions. So that's scenario one, fairly simple build out in that way. When we looked at scenario two, which again focused on a conservation heavy approach and a smart growth focused approach, we had more constraints on development. So we had prioritized protecting more land. We actually doubled the rate of conservation, but we allowed for some areas to be more densely developed. So when you look at these two overviews of scenario one versus scenario two, you can see this area here was a commercial property that in the future scenario two, we allowed to be a mixed use development that could both accommodate commercial as well as residential use. You can see some of these areas here are slightly more dense in terms of number of units per acre, but we were able to save more open space as well. So the development was a lot more compact in scenario two. And so just as an example, not to sort of pinpoint certain parcels, but here would be an example where if you had a commercial property like this, that's fairly old style, large parking area, strip mall type development. Maybe in the future, these areas are converted to more mixed use town center type feel, which are more walkable and also have sort of a mix of residential and commercial use. And when you look at the maps here of scenario one versus scenario two, I just wanted to pull out the red here is land that's lost to development. So new development, and you can see under the status quo across the island, a lot of open space is lost. In fact, all of the unprotected open space. But in scenario two, even though we're accommodating the same exact level of growth in terms of new units built, we lose far less open space and save much more. And that's simply because we have some denser developments that are able to, you know, be built more compactly and save rather than sort of sprawling subdivisions. And when you look at the numbers in scenario one, we lose around 3,000 acres. And in scenario two, which still incorporates development, including some subdivision development, we lose around 900 acres. So that difference of 2,100 acres is obviously fairly significant. It's nearly 10% of the island. So once we had those that data modeled out and the maps, we also looked at, okay, what are the impacts to our way of life and natural resources here on the island? And we did a number of these. I'm just going to share a couple just for time, for the sake of time. One of the things we did was just a scenic view analysis where we actually looked at somewhat subjectively, but various views that we believe folks find appealing on the island of open space or coastal views or different spots in the three towns. And we looked at how they might be altered between the two scenarios. And what we found was almost 90% of the views in the status quo by 2050 were at least somewhat compromised, and about a third in scenario 2 by 2050 were compromised. So a lot more of the viewscapes that we love so much here on the island were still intact in that scenario. Of course, farmland for Middletown and Portsmouth is so important. It contributes so much to the community. And what we found in the status quo scenario, that 3/4 of the unprotected farmland was lost to development. But in the plan and protect scenario, we only lost around 22% of that farmland. And of course, Aquidneck Island, I'm sure as most folks know, we're serviced here by surface water reservoirs primarily, which have drinking supply watersheds. And in the status quo scenario, with all the new development occurring, new impervious cover, less kind of natural open space, more lawns, the Suzaki was able to calculate what nutrient loading would be in terms of related to impervious surface, and found that the status quo scenario contributed much more nutrients, nitrogen, phosphorus, and suspended solids into the watershed. The other piece that we found when we looked at how these scenarios might impact tax revenue, which of course is very important, we found that because of the mixed use style development, that there was actually an 8.4% island-wide increase in annual tax revenue in the plan and protect scenario. Why is that the case? Primarily because mixed use, if you think about it, has commercial and residential use slightly more in a more dense setting. You get a lot more property tax revenue out of an acre than you do if you had suburban residential. So even though it's not mixed use all over the landscape, it's just certain areas that really contributed to increased revenue. The other thing that this report didn't get into really is a cost of service analysis. And we've seen in other communities, oftentimes a lot of new development has high infrastructure costs, has high costs to the school system. Those often offset the cost of the new tax revenue, while open space, farmland don't do that. The other piece we saw in both scenarios, just because we're seeing the same type units, is obviously more cars on the road. We had 8,000 more cars on the road in both scenarios. If you have somewhat denser areas like mixed use developments, ideally there would be a better public transportation system servicing those. So that may help in that regard as well. So again, more impacts are gone on to into the full report, and we will, I'll share the link on that shortly. We just highlighted a few here. And just before turning it back over to our panel, just a few key takeaways from the analysis. I think one of the most striking is that, on Aquidneck Island, land is a finite resource. There's only so much land left. And if we keep going at the status quo, we're going to run out of land by 2050. And I would guess, based on demand right now, probably far before that, either land will be gone or we will have protected it in some fashion. Of course, and that's a lot of farmland. It's our vistas, its ability to create new trails when that land is gone. So land conservation is certainly a way to help ensure some of that open space is saved. The other key point, the current trends we see are can be really detrimental to our natural resources here. Obviously, our water system here is very fragile. We're mostly all on surface water. Obviously, some folks have wells, but the current trends compared to the smart growth approach can be more harmful, and they also provide a lower per acre tax-based revenue. And then I think, certainly the municipalities make development decisions themselves, but regional planning is critical in the future as well. Obviously, our natural resources, our water here, our viewscapes, our recreational areas are in many ways shared between the communities. So, coordination and cooperation, we feel would certainly be helpful in thinking about the future of our island here. So that was just a brief analysis. If you leave questions in the Q&A, Chuck and I will try to answer them, or give us a shout later on. I'll also put up the report if you really want to dive in the chat feature.
Great. Thank you, Alex, very much. Eye-opening, sobering call to action. So that leads, I think, very logically to the next part of our workshop today, which is to have Caroline Wells and Ashley Sweet walk you through how you can influence the land use decision-making process, which can have a major influence on whether the more positive scenario in the ALT report comes to pass or the more negative scenario. So let me just tell you a little bit about Ashley and Caroline and then turn it over to them. Ashley Sweet is currently a project manager at the environmental and engineering consulting firm Weston and Sampson. She works with the company's water division on a variety of planning related topics. She has roughly 20 years of experience in the planning field, and that has included stints as the town planner in 3 Rhode Island communities: Exeter, Charlestown, and Hopkinton. She's, I believe, and Ashley, you may correct me on this, I think you're currently the president or very recently were the president of the Rhode Island chapter of the APA.
The incoming president.
Incoming, okay, all right. Ashley has a master's in community planning from URI and also an undergraduate degree from URI in marine and coastal policy and management. And in her career as a policy and land use consultant, she's represented developers and citizen groups regarding proposed development applications, serving as an intermediary on their behalf. So she's very qualified to be helping to lead this workshop tonight on citizen planning. She's also been a longtime advisor and trainer for GrowSmart Rhode Island, so we know her work directly and appreciate it a great deal. The same is the case for Caroline Wells, who's also done a lot of work with GrowSmart Rhode Island. And Caroline has numerous other credentials and accomplishments, including the following: 20 years of professional experience in the fields of urban and transportation planning, redevelopment, housing, and preservation. She's plied her craft for several different organizations, including the town of Warren, where we've worked with her quite closely in recent past years. She's trained and experienced in community outreach and engagement and has worked closely with diverse residents, neighborhoods, nonprofit organizations, and government entities on a variety of district and municipal plans. And she and her planning initiatives have won several awards, including one from GrowSmart Rhode Island several years ago, citing the town of Warren's numerous smart growth innovations during her tenure as the town's planner. So Ashley and Caroline, the floor, so to speak, is yours. And thank you so much for being an important part of tonight's workshop.
Thank you. Can you hear me okay, first of all?
Yes.
Great. So I'm going to start us off, and then Ashley will pick up in a little bit, and then we'll be going back and forth through the rest of the presentation. Please feel free to put questions in the chat, and if we need to stop, we're happy to stop and talk about particular issues as we go through this. Ideally, if we're all in the same room, we're having a conversation and it becomes more of a discussion. But through the Zoom profile, we'll figure out how to make all of this work together. So I'm going to advance through. We know all about the initiative. I want to just get touch base on the workshop goals. So some of this, it is a 101 presentation, so it may be very rudimentary for many people, but the idea is that we are creating a baseline of information so that we understand and we have a collective understanding of what land use planning is, what our regulatory documents are, what our goals for plans are, and then some of the legal requirements so that we can make sure that we're proceeding in a lawful way as we look at planning and planning regulations. once we get through this presentation, we hope that you'll come away with a better understanding of how planning and zoning works together. And also how you can work through the process to be an advocate for your causes. And more than anything, we also hope that you'll understand the need for consistency. We often as planners see people who show up during the planning process, but then once the plan's approved, they somehow fall away and think that things go on autopilot. Unfortunately, planning is at the very core of civic engagement. You have to always understand what your plan says, keep the plan alive, and keep it in front of politicians, because oftentimes politicians change over the life of a plan, and many of the incoming politicians don't necessarily know what the plan says or understand how it demonstrates the goals and vision of the community. So let's talk about what land use planning is. So land use planning is more than just a term. It's about our goals for the future, right? And it's also the tools that get us there. It's the entire mechanism. So we think about land use planning, and I think we just saw that in the Suzuki presentation, is that a lot of times there's a disconnect, right, between what we want our community to be and what our regulations actually say. And so we have to think about where we want to go, right, and come together as a collective community and have that conversation, and then put the regulations into play that will effectuate that vision, right? So it's all of those pieces. And as we say at the bottom, we often call it community land use planning because it really is about the community. Oftentimes land use planning is, or at least appears to be, the result of just private market decisions. But the private market decisions are part of what the community has to live with, right? It's part of our quality of life. And so that decision-making process is something that we need to be actively involved with. Here's a breakdown of how the process generally works. So I'm going to go through, it says here land use planning process, but generally, let's say a comprehensive plan, that's our big land use product, right? So we start at the top, and we're at this point data gathering. We're getting all of the technical data, sort of the demographics, the housing production, transportation and changes such as traffic loads and that sort of thing. Sometimes we go into business needs and industries. What is it that the community has going on right now? So there's a benchmarking phase. Another aspect to this is the community visioning phase. And that obviously goes through the whole process, but at the very beginning, what we're trying to see is the high level, what is the community value, right? So does the community love its scenic views? Does it really appreciate its open space? Where's the community's heart? And when we can gather those aspirations, then we can start aligning the technical data and the community data, and we can start weaving them together into a set of vision, goals, actions. And that is how the planning process generally comes together, but it's not done. We have to establish an action plan. Here it's called an implementation program, same thing. How are these visions and goals going to come about? Who's going to do it, right? So our action plans often give a who. Sometimes they can say how much money it'll cost, or where are our funding resources, and they'll often give a time frame. So how long will it take? So that we understand that the plan doesn't end with the plan has to move forward into reality, ideally. Many communities also put into place program evaluation. So they can do, for example, an annual reporting, or they can have a comprehensive plan committee whose job it is to make sure that the comprehensive plan is moving forward, or the land use plan. And so they create mechanisms like reporting mechanisms. In many places, they have to identify how new funding decisions, such as capital improvement programs, are actually realizing goals of the comprehensive plan. So there are ways of ensuring that the comprehensive plan or new land use plan, whatever it is is being realized. And if it's not, that should be noted as well, right? So if something's not working, rather than beat it every year and realize it's not working, it does help to do this evaluation and really understand, well, what's the missing piece? Is it political will? Is it funding? And then build different actions so that that can be overcome, or revisit your goals and your vision, your actions, and make sure that they're still in line with the community vision. So I just talked about the local comprehensive plan, but let me summarize it. It is the core document for municipalities. In Rhode Island, it's called a comprehensive plan. In many communities in Massachusetts, a master plan, but the same idea. And it is a document comprised of what we call different elements. And so, for example, one might be housing in neighborhoods. One might be transportation or multimodal transportation or active transportation. Land use, economic development. So each of these elements comprise an overall vision for the municipality. This document should be the foundation for policy decision-making within the municipality, certainly in regard to development and land use decisions. It is affected by, or I should say, it's realized by the zoning ordinance. So they often work together, and there's actually a legal requirement that your zoning ordinance be in conformance with your land use or your comprehensive plan. So these are two things that work together. So this is a lot of words on the page, and I believe that you will be supplied the PowerPoint after this. But essentially, your comprehensive plan is important because it sort of warehouses all of that technical data that you've just researched. It's a reference for the latest data that has been researched about the city or town, and it provides a rational form for decision making. And the idea is that it's the guide document that makes everything else sort of fall into place. It creates consistency across municipal documents. It also forges a better relationship between the town and its adjacent towns and the town or city and the state government. It gives the platform from which they can communicate about differing or similar policy goals. It also reduces conflict theoretically, or it can create conflict. But the idea is that it is the community statement about its own goals, and so it's the territory by which the community says this is what we want. So there's a certain uniformity and unity behind the comprehensive plan. I mentioned the zoning ordinance a bit before. Now, zoning is really the meat and potatoes of how development happens at the local level. And as you know, it can be very controversial, but in essence, its goal is to protect public health and safety. It's a way of creating a rational and fair way of development, theoretically. It also promotes design standards that the community may want and spells out how those design standards will be implemented. It can also create performance measures for certain uses, that is the standards by which we want to see development perform. And it focuses, well, I should get to the heart of it. It focuses on use. It focuses on dimensions, where a building can sit on a particular lot. Density of an area. Do we want it to be 3 or 4 stories high and very dense? Do we want it rural and spread out and low? And it can create even it can embody some architectural standards, particularly if it's a business district or historic district or something like that. A different tool are our subdivision regulations. Now, those are the tools that really talk to a particular site or a particular development. So if you're subdividing a land parcel, if you're developing a land parcel, or if you're sort of changing the use in a particular way, we call it development plan review. I'm not going to get into that, but it's peculiar to Rhode Island. And so this establishes the review procedures that planning boards will follow as they look at how a site is developed. And that can deal with the physical stormwater drainage, rights of way, landscaping requirements, sidewalks, lighting, that sort of thing. Many planning boards have tapped what they call a technical review committee, or a TRC, and that is a subset of the planning board. It can include planning board members. It can also include department heads or other sort of technical experts in the field to offer applicants a sort of non-public or as public way of talking through the nuts and bolts of a particular development. And it can be very helpful for planning boards because it kind of takes the spotlight off and allows for conversation to happen. So many communities use a TRC. There are also different types of zoning tools that we use, more specialized ordinances, as we see here: historic districts, conservation, water management. There can be specialized districts with their own standards. And you know, there's not much more to say about it, except that it's a very useful way to tailor the zoning of an area to its very, very hyper-local needs. Another way of doing the same thing is to create an overlay district. You'll often see this in waterfront areas or for areas that are, for example, like water resource protection areas. Maybe there's no sewer in an area, it's all septic. And so we want to make sure that people who are drinking out of wells are drinking clean water. So we regulate those areas through overlay districts. And an overlay district is a zoning district that is literally what we say, it lays over another district. So it includes both of the standards of both zoning districts at the same time. So that's the end of my part. I'm going to shift it over to Ashley. We thought about giving a quiz, but then we decided not to, but maybe next time we will. So ask yourself, you get a pass this time. Ask yourself, do you remember what is land use planning? And how do we plan for our land uses? And what tools do we use? And keep that in mind. And if you have any questions, I'm happy to answer now or later. All right, Ashley, it's all you.
All right, thank you, Caroline. So the section I'm going to go through with you is going to talk about who makes these land use decisions, what roles each of these bodies play in land use decisions, and what those review processes are. So we'll start at the top with the town council. So the town council is going to be the body that makes decisions about those plans that Caroline kind of went through with you. So they enact and amend comprehensive plans and zoning ordinances. They're going to approve special overlay districts or master plans, and they're going to hear recommendations from planning and zoning boards in order to kind of make those decisions. In general, town councils are not the land use experts in a community. They rely on planning boards and zoning boards and town staff to provide them with these comprehensive plan updates and amendments and zoning ordinances, and then give them the guidance that they need. But they ultimately are the ones that approve or deny those end products. And that's the functional role that they play in this process. So they're way at the top. And everything is kind of filtered up to them from the planning board, zoning board, and planning staff. So the planning board themselves, they are in charge of their land development and subdivision regulations. They have authority in enabling legislation to make changes, to draft, make changes to those land development and subdivision regulations. And they have the sole authority to do that. They don't need to go to the town council and ask for the town council to bless those changes. They get to make them on their own. And there's a process that's laid out in state law. It does require a public hearing, so there is opportunity for the town to provide it, for residents to provide input during that process. But this is the one set of regulations or plans that doesn't make it to the town council level for approval. It stays with that approval authority, stays with the planning board. And then they use, back up 1 second. They use those subdivision and land development regulations to review site plans for permitted uses. They have the authority to approve and deny subdivisions and land development projects. They're the body that's responsible in coordination with the planning department to draft and update comprehensive plans. And they are able to initiate amendments to the zoning ordinance and send recommendations to the council on comprehensive plan and zoning amendments. So if a comprehensive plan amendment or zoning amendment is proposed by someone other than the planning board, they are statutorily required to review that amendment and make findings on its consistency internally with the comprehensive plan itself, and then also with the zoning ordinance. And that gets sent to the town council as an advisory. And that's the town council, you hope, relies on that planning board's expert knowledge of how these documents interplay with each other, and takes that advisory opinion and then makes a decision ultimately at the town council level, whether it gets approved or not. Okay, Caroline.
Thanks.
Zoning board plays a different role in the sense that they are less involved in the policy making and more involved in the implementation role. So the basic function of a zoning board is to grant relief from the zoning ordinance. And that comes by way of variances. They can approve and deny special use permits. And we'll talk a little bit more about what each of these is a little later on. They sit as the review body for the planning board and for the zoning enforcement officer. So if the zoning enforcement officer makes a decision and the applicant is not pleased, they can go to the zoning board on an appeal. Same thing with the planning board. They sit as the review body for the planning board's decisions. They do not enforce the zoning ordinance. They also don't draft the zoning ordinance. They are the body that essentially, when somebody can't comply, makes an application to the zoning board for that non-compliance and requests that permission. Go ahead. Another kind of subset, not all towns have these, but there is historic district commissions, which are also enabled in state law, and they carry a significant amount of authority when they are when there is a historic district and when they are established in the town. So they have oversight to ensure that historic character in that district is maintained. So they get approval and denial authority over alterations and new construction activities in any place where the town has designated a historic district. And that is done by way of an overlay. It can be done by way of an overlay, a historic district overlay, which is designed to preserve architecture and character. And that overlay district would be approved by the city council or town council, and most likely would have been drafted by the planning board. So you can kind of see how each of them play a role. All of those roles are intertwined and kind of get handed from one to the other for a completed product that ends up at the town council level. So this is a kind of a chart that gives you an idea of how all of these things happen and each of the roles that they play. I'm not going to go through this for you. It'll be available to you kind of as a guide to refer back to if you ever wonder about the role of any of these organizations within a town. So now we'll talk a little bit about the review process that actually comes out of those documents that we discussed. And so for zoning, as I said, zoning is enabled in state law, and the community is tasked with drafting and implementing their zoning ordinance. And the decisions that are made by the zoning board relate to, like I said, that non-compliance. So in the case of a dimensional variance, it might be that somebody can't meet a side setback for a deck or a shed, and it's dimensional in nature. They might exceed, lot coverage, and things like that are before the zoning board as dimensional variances. And there are standards by which the zoning board has to weigh the application against. And so it gets into issues like the character of the area, that it's not due to a physical or economic disability of the applicant, that it's not a hardship that they created for themselves that they now come back and ask for relief for, that it's not primarily for financial gain, that it won't impair the other intent and purposes of the zoning ordinance, and that it's the least relief necessary. So if there are alternative ways that they can accomplish the same goal that would result in less relief, the zoning board has to make those findings and be able to positively find on these issues to be able to approve an application for a dimensional variance. So that the next type of relief or permission that's granted by the zoning board is a special use permit. And again, that is there's enabling legislation for the municipality to set these standards. And so a special use permit comes into play when a community might have a use that in general they wouldn't have a problem with, but there are certain circumstances that need further review. So we might be looking at maybe a higher intensity use where there might be, excess traffic generated, or there might be noise issues that are of a concern. And so this takes that permitting process one step further and says, the community is essentially saying, in general, we're okay with this type of use, but we really want an added layer of protection and review. And in the process, the zoning board has the ability to attach conditions that have to relate back to implementing that comprehensive plan and zoning ordinance. So these are you'll find special use permits in the zoning ordinance are identified in the use tables, where you can look at the use and then determine in the district that it's permissible by special use, and then you'd make application to the zoning board and make those requests to the zoning board. And so the final type of application before a zoning board is a use variance. And these are supposed to be used in very rare circumstances. This is essentially under a condition where the applicant can say, I have no other beneficial use of the property. So in the zoning ordinance, the use that I'm requesting is not allowed. But if you don't grant me a variance on that to use it as I've asked, I have no other good use of the property. So they should be very rare circumstances. I don't know that everybody keeps them as rare circumstances, but that is the intent, is to say, because you can't draft a zoning ordinance that's going to cover everything. So when you have those unique circumstances where a particular use is not allowed, this is the outlet in which an applicant can come forward and say, it's not allowed, but if you don't let me do it, I literally have no other beneficial use of the property. And then they're also held to those standards you see there, that it's unique to the characteristics of the property. Again, it talks about the surrounding area and not having any negative impacts, again, about a physical and economic disability, that again, the applicant did not kind of create this situation for themselves by some prior action, and that it there it says you can't benefit any beneficial use is required to conform to the provisions of the zoning ordinance. And again, they can attach conditions to promote the intent and purposes of the zoning ordinance in approving any use variance. So now we're going to take a look at the planning board and what roles they play in the land review process. So they are also held to required findings in any decisions that they make, those being comprehensive plan consistency, zoning ordinance consistency, a finding of no significant environmental impacts. They're not allowed to create lots that have physical constraints to development. So they can't create a lot that, for example, has no street frontage. You can see it says there adequate and permanent access to a public street. And then the municipality is also able to add additional findings. You'll see if you if you ever get bored and peruse some subdivision regulations out there. Some communities have expanded upon these and gone further to talk about additional requirements. And they have to meet the minimum standards that are stated in the regulations. So when we're talking about physical design requirements, there's often landscaping requirements. There are street and roadway design requirements, public improvements, sidewalks and lighting and access and utilities and stormwater are all contained within those subdivision regulations and set the standards by which development must meet. And the planning board has to be able to say in any decision that they make on these applications that they've met all of the requirements. So there's a couple of different ways that the planning board can use the subdivision regulations, and you've probably heard of some of these. These are kind of the tools that are out there for land development. We have conservation developments, and these are typically residential subdivisions, and it's just a different way of designing the subdivision. It's the idea behind it being that instead of just taking the raw land and saying if it's a 2-acre zone, I'm going to put a street down the middle of it and I'm going to cut off 2-acre lots along the street frontage and be done. The idea behind it is you're going to look more carefully at the physical constraints of the property, the characteristics of the property. And ideally, you would want to take whatever the density is allowed and minimize the impacted area and choosing the less environmentally sensitive parts of the property and placing the development in those locations. And so with a 2-acre density, you might have 10 house lots, and you might take those 10 house lots and put them, instead of putting them on the entire property, you shrink them down, put them on a portion of the property, and then the rest of the lot is conserved as open space. So the lot size is reduced, but the density remains the same. Residential compounds are a tool that can be used by a municipality where there's kind of a trade-off between the developer and the town. The developer gets to put in less infrastructure. Generally, that's done by way of the roadway. So instead of having to put in a town road with pavement and all of the components that go along with putting in that infrastructure, I can put in a dirt road. And I get to spend less money on the roadway. The town benefits and gets less development density than a conventional subdivision. They also get less infrastructure to take care of at the end. So it's usually a trade-off that benefits both parties. And then we have land development projects. These are usually multiple buildings on a single site. They can be a mix of both residential and non-residential uses. They go through a very similar process that a residential subdivision would go through, but this is a mix of uses on the same piece of property, as opposed to dividing up residential land for single-family development. So we're going to briefly take a look at the two types of review processes for a planning board, for subdivisions. There's a major subdivision process, and this is triggered when you have 6 or more lots. There are 4 required stages, and this is all enabled in state law. The individual decision-making for the municipality comes in to play with what the design standards are, what the infrastructure standards are, and then what's required at each stage of review for submission. The municipality has some flexibility there. They can request certain items at each stage of review. And a pre-application is the initial stage. This is more of a conversation. The applicant can come in, they can meet informally with the planning board. They don't have to have hard engineering. They can have essentially kind of like pretty pictures that they can show to provide the planning board with an opportunity to react to a concept. There's no decision making that happens at this stage. The planning board is not bound by anything that's said. It's a casual conversation, and it's intended to give the applicant feedback so that when they come back at the next stage of review with some design, they've already taken the temperature of the planning board and gotten a good feel for what they liked and what they didn't like. So it is designed to benefit both parties. The applicant can typically save some money by not coming in with something that the planning board ends up disliking. That should get kind of flushed out at that pre-application meeting. And once that takes place, the applicant comes in at a master plan. And I've been doing this for 20 years, and I still can't get over the fact that they labeled these the way that they did when they wrote the enabling legislation, because it is not intuitive. You would think a master plan is the plan. A master plan is conceptual, as opposed to a preliminary plan, which is not conceptual. So that's one of the things you have to get over in planning in Rhode Island. The master plan is intended to be conceptual. The applicant does need to come in with some engineering. They need to be able to provide a site plan. They have to be able to talk intelligently and display on a site plan intelligently where that roadway is going to be, where those lot lines are going to be, where in general, stormwater infrastructure is going to happen. But it's not a full engineered design. It's taking those pretty pictures and the feedback that they got on them at pre-application and flushing those plans out a little bit more and providing some more detail. Once that's done, there is an approval process at that point. The planning board is required to, for a major subdivision, there's a public informational meeting at that stage of the review. And so the abutters would get notified that this is taking place, and they would have the opportunity to participate in that public meeting and to provide their comments and feedback as well. And once that happens, the applicant disappears, usually for a while, because at preliminary plan, you've got to come back with state permits. So they leave for a little bit and they do their engineering and they apply for their state permits, whether it's DOT or DEM or Department of Health, depending on what type of application we're looking at. And they come back with fully engineered plans. They come back with state permits in hand. And they present this to the planning board, and the planning board does their review of all of that additional information that they're now being provided with since the master plan. There is a requirement for a public hearing at that stage. Again, the public gets notified, it's advertised in the newspaper, and the general public is invited to participate in the process and provide their feedback and comments as well. And then the final plan stage, depending on how the application goes, it's either finished by the planner. The planning board has the authority to grant administrative approval to the planner, or they can require the applicant to come back to the board for a final approval. And at each of these stages, master plan and preliminary, both of the master plan and the preliminary plan, the planning board has the ability to condition the application. So they can say to the applicant, we're going to approve your master plan, but we're going to condition you and tell you that when you return, you have to provide this. And that conditioning, like I said, can happen at both the master plan and the preliminary plan stage of review. So we'll take a look now at minor subdivisions. So that application review process happens when you have 5 or fewer lots. There are typically 3 stages of review with a minor subdivision. A pre-application is not required, but I've always said that it's a good idea. It not only benefits the applicant, but it benefits the town. It doesn't make sense for the applicant to come in a minor subdivision with a preliminary plan, because those preliminary plans are engineered plans, and it doesn't behoove the applicant to go spend the money to engineer plans, to show up and find out that the planning board's not thrilled with what you've designed. So that's what the pre-application is for. So although it is not required, it is encouraged. And it's that free flow of information between the planning board and the applicant to talk about what they like and what they don't like, and what the expectations are going forward when they return for preliminary with those engineered plans. So a preliminary plan, there is no public hearing requirement unless there is a street creation. So if you're, as part of your 5 or less lot subdivision, you are installing a town road, then you would have to have a public hearing. But if that town road is not a component of your 5 or less lot subdivision, there is no requirement to have a public hearing. And then again, with the final plan on these, it is up to the planning board whether the planner has administrative authority to approve, or whether the planning board would like to see the application return, and provide the review and approval themselves. And so at the preliminary plan stage here in a minor subdivision is when we would typically see conditions of approval from the planning board. And so another component of this is, how does the planning board kind of decide what to approve? And this is, I think, something that's often confused for the public. They're required to make their decisions based on what's in the regulations. There's a little bit of room for preference when we're talking about things like landscaping and design. But if the applicant is meeting the regulations and they're complying with the standards, that's the fundamental, necessary benchmark to make for an application to be able to be approved. They cannot make these decisions based on opinion. If the land is zoned for the use and it meets all of the requirements, the planning board really doesn't have much legal standing to deny an application.
Ashley, there's a question, and I don't know if you want to answer it now, but it's pertinent. Sure. I'll just read it.
Okay.
Is it correct to say that if the master plan is approved, the approval is the green light for the applicant to spend money? This vets the applicant, and it is almost an obligation for the application to be approved at preliminary plan, and the public input part of it is then moot.
So that's like a yes and a no at the same time. And Caroline, feel free to jump in as we answer, but the vesting is correct. An application is vested at master plan. But what does vested mean? It means generally the concept is okay. It's conceptually the planning board feels comfortable. That's not to say that there's an obligation to then approve a preliminary plan. The applicant needs to go back and start to engineer this kind of conceptual design that they have presented. If that engineering in some respect falls apart, the planning board can't approve a preliminary plan if it cannot secure state permitting, if it cannot say if they cannot prove that they meet the standards. So conceptually, they can say, this is how we're going to handle our stormwater, and they might get an approval at the master plan stage of review. But then if they show up at DEM and DEM is like, this doesn't work, you cannot do this, we're not going to permit it, they're going to have to go back to the drawing board and redesign and kind of backpedal that master plan approval and change around how they've designed something, and then come back and show the planning board that they had to make these changes. So, and I wouldn't say that the public input is moot. Certainly public input is valuable all throughout the process. I will tell you, as someone who has represented both abutters and developers before planning and zoning boards, if you don't make your case at the master plan stage as an abutter or as a citizen group, or even as the developer, it's pretty tough to change things after that. So I think that's why this is like a yes and a no question. It really is going to fall to, if the applicant can't deliver what they said they could at master plan for some reason, then things would have to change. But it is difficult to pull back an application once a master plan has been approved.
I would agree with all of that. I've actually seen a preliminary plan rejected after it was approved as a master plan, but that is a recipe for a lawsuit.
Yeah.
And
it's very
so
hard.
that's the lens by which both the town and the planning board tend to regard things is are we going to go to court over this? And that's how they make their decisions. But it also points to why a comprehensive plan should be fairly specific and updated. So the example I just referred to, I believe, was a solar farm. And the comprehensive plan said something to the effect of, well, we will preserve our rural landscapes. Very vague. And so when a rather large solar farm was proposed, I mean, it kind of makes it a matter of perception, right? Is that, is that going to offend your rural landscape or not? And so the community really was outraged between the master plan and the preliminary, and then the planning board changed because they realized that the community had interpreted their comprehensive plan differently. Again, this is the fodder for lawsuits.
Yeah, and interpretation is a big piece of that. I have, as I said, if a citizen group comes in and comes forward and says, we want to oppose this application, it can become a situation of the dueling experts, where I may be an expert for a citizen group, the developer has their own expert. We're reading the same documents, we're looking at the same plan, and we're coming to two very different conclusions. I'm making a case that this doesn't comply with the comprehensive plan. Obviously, the expert for the applicant is coming to a very different conclusion to say that this does comply, again, from the same document. And it becomes an issue of who's more credible, who has a better argument, who did a better job of making their case. And so that's why perception and interpretation are really big components of how this plays out. You can come to two very different decisions, looking at the same application and looking at the same comprehensive plan. I hope that answered the question.
Sounds good. All right, so let's move on. We can pick up some other stuff later. Sorry.
So this is a little bit of a hard slide to read from here, but hopefully you can use this, on your own time to kind of take a look at. And this is just a little bit of a flow chart that gives you an idea that we start with whichever public body is responsible for adopting the rules of procedure. And then once that's established, it becomes an issue of when an application is made. And so an application is made to the community. It has to, initially it's submitted to, in the case of like a subdivision, it would be submitted to the planning department. It has to be certified complete or incomplete by the administrative officer, which is typically the town planner. And in that case, it's a review of the materials submitted and against a checklist in the subdivision regulations that says, in order to pass go for this stage of review, these are all of the items that need to be supplied. It's not a review in the sense of the planner is necessarily looking at well, do we like the way this street was designed, or do we like the way the subdivision was cut up? It's more of a, did you check the box? The review of all of the materials in terms of their content comes at the time when the planner does a review and provides an advisory opinion essentially to the planning board, and then we go to a meeting and that all kind of comes out and gets discussed. And there are time frames that for a lot of these things to happen. And that's what you see those little clocks there. The enabling law legislation says you only have a certain amount of time that you can take to do these. And so it's a way of, making sure that the planner and the staff and the planning boards and zoning boards are all kind of making these decisions in a timely fashion. And so that an applicant is not, you can't use time against them essentially. So that's the end of my section where we've kind of talked about, who makes these decisions, how do they make those decisions? And if there's additional questions, I'm happy to take them now, or we can kind of go to the end and I'll talk at the end. I see one thing in the question and answer.
Yeah, it's, I think it's the same questioner. It talks about how the right and the insignificant alteration permits have a disclaimer on the back. Yep. In quotations. And in quotations, it says, in permitting the proposed alterations, the DEM assumes no responsibility for damages resulting from faulty design or construction, end quote. Is the DEM actually saying something will work or not work, or simply awarding documents required for application completion?
So I think they're not, that's their disclaimer that if it's not installed the way you say you're gonna install it on the paper that we approved, we're not responsible, someone else is. They're reviewing what's on a piece of paper in terms of what's designed. They have to rely on the fact that somewhere after they've given this insignificant alteration, that it's actually going to happen the way that it said it was on the paper. And I think this is a problem across Rhode Island in the sense that a lot of municipalities are short-staffed. DEM is not going to follow up and come out and check on these things in every single instance. If somebody calls and says it's not functioning or they're not doing it correctly, then they're obligated to respond. But it falls on the municipality really once the DEM has said, okay, you've designed this, we approve of your design. It kind of falls back on the municipality to make sure that it's actually getting installed properly and it's going to function correctly.
Okay, we have another question. Can the number of lots be changed in an application after the master plan review?
So I would say yes. My question for somebody who did ask, who did do that would be, why are we changing? Are we changing because, DEM came back and said, you can't do what you say you're going to do? Are we changing? What's the reason we're changing for? And then the next component of it would be, what's the magnitude of the change? Are we going from 10 lots to 20 lots? Or are we going from 10 lots to 11 lots or maybe 9 lots? If we're going from 10 to 20 lots, certainly if I were sitting in the seat as the administrative officer or the planner, I would say, you go back to the beginning. You don't get to swap it out and show up at preliminary with double the number of lots. That nothing you've proposed at master plan works anymore. So you don't get to transfer that forward. So it really depends on the reason for the change and the magnitude of the change.
What we should also add, though, that there is the possibility in state law of combining master and preliminary plans. There's a one-stop shop. And sometimes it works very well, and sometimes it's a backdoor for really bad development. But it is possible that somebody could come back and apply for a combined master preliminary if they have all of their permits and their ducks in a row.
And I think a general rule of thumb for something like that is, I think that that's typically an appropriate thing to do when a smaller development is happening, if we're right at the threshold of 6 lots. If it's very straightforward and there's, if we're only cutting off, say, frontage lots, there's no road design, there's very little stormwater infrastructure involved in something like that. Or if we're in a situation where what would be normally considered a minor subdivision gets pushed up to a major subdivision, not because of the number of lots, but because there is a waiver involved in the process and the state law triggers that review. So if you had, a 3-lot subdivision, but there's some kind of waiver involved in the application, the state law bumps that up to a major subdivision, which would require you to go through extra stages of review. And in those circumstances, it might be appropriate to kind of combine those review stages.
Yes. But I have also seen where a developer will come in and say, I would like to get on the docket for a combined master preliminary plan. Oh, but I also want to ask for a waiver for all of my permits. And
Yep.
And so, we get a lot of strange stuff.
And it does fall on the planning board. The administrative officer or the town planner cannot grant relief unless it's explicitly stated in the subdivision regulations. So if your subdivision regulations don't grant authority to the administrative officer or the town planner to make those determinations, only the planning board can do it. So it would go to the planning board as a request to combine those stages of review. And if the applicant can't convince the planning board that that's appropriate, then they can't do it.
Great, good questions. Okay.
Hey, Ashley, can you talk a minute about waivers and modifications in the planning board process?
Sure. So it really goes to how your subdivision regulations are drafted. It also goes to how your zoning ordinances are drafted. I have been involved in the drafting of zoning ordinances where the intent was to provide flexibility, and to not make an applicant go to the zoning board for relief every time they couldn't meet a standard. So you can build that flexibility into your zoning ordinance, but statutorily, the planning board doesn't have the authority unless you create it in your zoning ordinance. So I'll give you an example. In Exeter, we wrote a solar ordinance, and we really wanted the planning board to have the opportunity to work with the applicant to kind of do some trade-offs, and to be able to flex certain pieces of the requirement. So for instance, in some locations, it would be very appropriate to have 300-foot vegetated buffers, but in other locations that might not make any sense, or there might be certain areas of the site where you couldn't meet those requirements, but the solar installation made more sense in a location where you couldn't meet those requirements. We didn't want to send the applicant to the zoning board every single time we needed that to happen. So we built in that flexibility for the planning board, because if you remember what Caroline reviewed, the zoning board only kind of is there to grant that relief. They don't draft the zoning ordinance. They don't enforce the zoning ordinance. So there's a disconnect there in the sense that the planning board is better equipped in some of these circumstances to be able to offer that flexibility and to be able to work with an applicant as part of the review process. So when the flexibility is not built in, you're essentially taking a site design review and then taking it out of the planning board's hands, sending it over to zoning and saying, you haven't seen any of these components, you haven't been part of this discussion, but will you let them, not meet the setbacks? So it's a little disconnected when you do it that way, but it is the way it was initially designed in enabling legislation. One thing we should add to, Caroline, that I just thought of is there was enabling legislation passed that combines the authority. So a municipality can adopt a combined authority essentially, and you have to write it into your zoning ordinance, where if as part of a subdivision or a major land development project, if relief is needed from the zoning ordinance, you can grant the authority to your zoning board to grant that dimensional relief.
Planning board, Ashley, I believe.
Excuse me, planning board. You can grant
Yeah.
it to the planning board to
'Cause I'm
offer
on the
that.
zoning board in Providence, and we do have that provision. It's often called Unified Development Review.
Yes.
Okay, we
But
do have
with
one more
those-
question. Go ahead.
Sorry. With those waivers, is the standard that the planning board is deciding it similar to what the zoning board would have used for criteria? It
So
seems like the criteria is different.
the planning board can grant exceptions to their regulations within the confines of the required findings for subdivision and land development review. So they're not the same set of standards that the zoning board is bound by. The planning board could grant relief from the subdivision regulations, as long as they can say that relief still meets the required findings for any decision that they're making on an application.
Okay, thank you.
Okay, one more question. If there is no town water or town sewer, could further information on the status of groundwater conditions be a legitimate reason to change the number of lots?
Yes and no. I mean, it really depends. I think you couldn't do it on the supposition that there is groundwater issues. You'd need some data. You'd need some science behind that to be able to say, we had and in a lot of cases, the applicant is going to provide the information. The planning board has the ability, if they don't have in-house expertise, which most don't, they have the ability to hire outside consultants. You have to write this into your subdivision regulations, but if it's in there, you have the ability to hire outside consultants to essentially peer review what the applicant has provided. So you can have a traffic expert at the applicant's expense. You bring in an independent traffic expert, they do a review of the applicant's traffic study, and they report back to the planning board to say, yes, this meets all the standards in our professional opinion, or here are the holes in their analysis, and this is what we would recommend. And you could do the same type of thing with water. I'm thinking of an application that's currently before a town where there are known groundwater contamination issues, and the applicant is requesting to put in 12 condominium units on a pretty confined space. And so there are serious concerns about what is this going to do to the known groundwater contamination. And so the applicant has hired an expert that has presented on their behalf, and it would probably benefit the town and the residents of that general area to have that peer reviewed. Bring in your own water expert, find out what that water expert thinks of the report that was submitted, and then again, it becomes kind of a dueling expert type of thing. But in the case when the town is having it peer reviewed, you really want to be able to rely on that and say that would be a good instance where if a peer review was done and the peer reviewer found issue with the applicant's hydrologic report, that could be a grounds for making changes to an application, I would say.
Great. All right, thank you. Let's shift gears. So the remainder of the presentation is going to be a little less formal, and it's really about sort of the behind the scenes activities that happen, but also about public hearings. And so it's kind of a wrap up to everything that we've talked about, because public hearings are sort of where the most visible place where the public actually interacts with the boards and hears applications and comments directly on the applications. And from the planning perspective, what we do is we listen very closely at these public hearings so that we can create the final record of the project. We write up, usually in tandem with the solicitor's office, decision for every action of the planning board or the zoning board, and we create a record. So it literally is a record file with all of the written commentary, opinions, reports, and studies, permits, application, all become part of a record that is public documents. So anybody can review it, and any decision should reflect only what is in that record. I'm sure you're familiar with the Secretary of State website. All public bodies are required to post their agendas on the Secretary of State website. If it is not on the website, it's not a legitimate meeting for a public board. And that actually also applies to any working groups under the board, subcommittees, and any subdivisions of the board. Usually that's handled by staff. Notice if you're looking for a meeting, you should be able to find it on the Secretary of State website. They don't always post minutes. That was supposed to be something that we were all supposed to do, but I noticed that many people don't post their minutes. But you should always see meeting time, dates, and locations, and be able to click on an agenda and see what's on the agenda. So a public notice, a proper public notice, should give the public substantial detail so that they know exactly what is being heard at a hearing, not just the location, but the proposed application, and what is actually on the docket to be examined. So in this case, we have obviously the name of the board, the date, the location. We have project details on number 3. And it also tells people where they can view the plans. Any other policies. So many planning boards put their adjournment. So what they'll say is that any items, say after 10 p.m. will either roll onto the next agenda or they'll set up a special meeting. And then of course we have accessibility information. So all of these elements constitute a proper notice. Now, a public hearing is often confused by people with a public meeting. A public meeting is any meeting which may or may not include participation by the public. So that could be your historic district commission, that could be your comprehensive plan committee, it could be anybody who is a public body. A public hearing is a different matter. It has to be advertised in the newspaper. It's supposed to collect public input, so you have to set up the room. We've had public hearings where we know over 100 people will show up, and so there's a lot of planning that can go into place when you know it's a controversial item. Here, I'll just advance the slide. So public testimony is taken at a public hearing. So if you're giving testimony, you're usually sworn in. You have to identify yourself, give your address, and state your opinion. Sometimes the chair, particularly if they have a lot of people, they'll say, if you're going to say the same thing as somebody else said, then you can just come up and say that and say, I agree with somebody, rather than reiterate what other people have said. But the public hearing is really critical. It's the main way in which the public gets to express its opinions on a particular application. And challenge the applicants on information provided. What usually happens is that the applicant actually has the opportunity to rebut some of the statements afterwards. Ashley, do you have any other things to add on this slide? Because it's
Nope,
pretty much
I
it.
think we covered it.
Yeah. So here's how a public hearing would generally work. Your chair, a good chair, will take command of how the public hearing works. Staff will make a presentation of the application, introduce the application, which is very typical of a planning board meeting. They'll list all of the materials. Nowadays, a lot of times they'll have it up on a screen someplace in the room. Then the applicant provides their overview of the project. Other public experts, sometimes the public works director, frequently will speak to different issues of the application. Other professionals, town engineer, for example, will speak to issues of the application. And then the public hearing will open up to the public. And so people can, usually in order, and there'll usually be rules. You have 3 minutes, state your name. People will go through their various opinions supporting or opposing the application. Then when that's through, the applicant, like I said, will have the opportunity to rebut. And then the public hearing will close and staff will take all of that into the record for preparation of the decision. So if you are speaking up at a public hearing, these are just sort of tips to help be one of the good guys at the public hearing, which is to be very clear and calm and to identify yourself, kind of introduce your argument, back it up with oftentimes people will come with photographs or with some firsthand information, and then reiterate your point, and then say thank you and leave. That's always the best way. People who rant or emotional are often cut off by the planning board chair, and just doesn't help their case. So you can also provide written comments. The way I've seen it and done it is that a lot of times people are not comfortable speaking up in public, certainly on television or in front of audiences. So you can send a letter addressed to the planning board. Usually it goes by way of town staff or the town planner. And you can follow up with oral written testimony. And so it's just another way of getting your feedback. There's nothing to prevent you from doing both, so that you are making your opinions known. And as I said, all of this forms part of the public record. So anybody at any point can do a request for information, or if they want to, they can come into a planning office and say, I'd really like to see the file for, some particular application. That can happen, and in which case they get to sit down and just read through the file. There are some cases where the town solicitor might want to review the file in advance to make sure that there's no privileged communications between the attorney and client that are somehow wedged into that file. So sometimes the solicitor may say, put in a request for information first, so that triggers a certain process that has to be performed before the public can view the file. But other than that, it is all public record. And usually the request for information notices are housed with the town clerk or city clerk. And that's basically the end of our sort of administrative piece of the presentation. So we talked about meeting notices and how to participate, the types of meetings, a public meeting versus a public hearing, and how to maximize your ability to speak in a public setting. So are there any, oops, I do have a question.
Caroline, can I just make one elaboration? This is from when my Providence zoning board hat on. I just want people to know that at least for every zoning board meeting, the public has an opportunity to comment on each application, even though it may not be, I don't know if it's labeled a public hearing. It's certainly a public meeting, but And that's a standard. Of course, we make our decision immediately. So if you want to provide written testimony on a zoning case, do it before the meeting. You're not going to have any influence by doing it after the meeting in most cases. I just wanted to point that out as far as the zoning board process.
I think that's a good point with the zone. When you're before the zoning board, there is a public component for each application. The public is asked, is asked if they have comments. In the planning piece of it, there are certain stages where public comment is required. So for instance, that major subdivision application that we went over, both at the master plan and at the preliminary stage of review, there is a requirement for that public component where it has to be advertised as a public meeting. It has to be notice, has to be provided to abutters. And there's a requirement in the enabling legislation that says that you shall recognize the public at these two stages of review. That's not required at pre-app. It's not required at final. It's not required in a minor subdivision that does not have street creation. Although I've not seen a planning board that has denied public comment during any of that. So it's not mandated, but general practice is that planning boards will often recognize the public during any stage of review, even if it's not mandatory. But it is part of every zoning application.
Very good.
Caroline,
Go ahead.
can I raise something?
Sure.
And as Scott was speaking with his Providence zoning board hat on, I am speaking with my Newport zoning board hat on. But the one thing I would say to people in public speaking, if they're speaking on behalf of or against an application, it's important to know the criteria under which the board is making its decision and try to frame your arguments within that criteria, because that is the meat of it for the board. So to the extent that you can frame your arguments within that set of criteria, it makes it so much easier for the board to understand your argument and to use it.
Yes.
I think, oh, go ahead, Caroline.
Well, I was just going to say the question in the chat sort of relates to that issue, which is what type of evidence presented by the general public could be considered by a board member and qualify as support for that board member's decision. But anyway.
I was just going to say, I think that's a very good point. I've been at countless public meetings where there is a distinct sentiment from the public that they don't like the application, and they stand up before the board and they implore the board, we're begging you, please don't approve this. This is terrible. You're going to destroy my quality of life. That's not the zoning board and planning board can't rely on that type of testimony to deny an application. They're held to certain standards and findings, and you are absolutely best suited to understand what those findings are and to tailor your comments to address them. I was at a contentious town council meeting last night on a zone change. It was 6.5 hours long because public comment was plentiful. And there was, I'm begging you, I'm pleading with you, you cannot do this. You're going to destroy, everything. That's just not a foundation on which a board can make a decision. They need to make it based on those findings. They need to make it based on data and facts and science. So as much as you can tailor those comments in that direction, you're helping them listen to you. And it's a very difficult position for a board member to be in. Their constituents, the people that they live in the community with, are asking them to please not do this, but there's nobody providing enough information about those standards and giving them those reasons that they actually could deny an application. So they're caught in a very awkward position where they want to work with the community. They want to do what's best for the community, but they are held to certain standards that are essentially written on paper, that they have to come to in order to make those decisions.
Ashley, I just want to interject. I draw a distinction between the kind of testimony that's appropriate before a city or town council and the kind of testimony that's appropriate / effective before a zoning or planning board.
Sure.
I view a town council as in some ways a political body. And so I think I think you can be more emotional and still be effective with a town council than you can be with a planning board or a zoning board, which are, at least in the case of a zoning board, it's been drilled into my head by the lawyers on the board that the zoning board is a quasi-judicial body. A town council is not a quasi-judicial body. It's more raw politics. That's my perspective. And that's what my former political consultants had on, as well as my zoning board had.
I would agree with that completely. I think the conflict there comes to a point where, like, for instance, we had a planning board advisory opinion that was supportive of a zone change, yet you had a group of people in the public that were imploring this council not to approve this zoning amendment, all based on emotion, not based on anything that they could really grab onto. And so then you have a situation where a town council has their advisory opinion, which is based on fact and based on science and based on expert testimony and based on the knowledge and understanding of the planning board, whether or not it's consistent with the comprehensive plan. On the other side of that is an emotional response. So I agree completely. I think you can be emotional in front of a town council, much more so than you can be in front of a zoning board or planning board. But if they're presented with the same information that the planning board based their decision on, it still creates kind of a tough situation for them.
Sure. And I'm not saying that's always going to work with councils.
No,
I'm just saying it's more at least permissible or defensible in the case.
And sometimes it does work. I mean, sometimes despite the advisory opinion of a planning board, despite the fact that they came to the conclusion that it was consistent or wasn't consistent, the town council will make a very political decision that's not based on any of that.
And I think another important thing for people in the audience to understand is that city and town council members in all communities in Rhode Island are elected. That's the key word. They're elected. I believe, with maybe one exception, all the members of zoning boards and planning boards in Rhode Island are appointed.
That's
so
true.
They're a little more, those people on planning boards and zoning boards are a little more insulated from political considerations and certainly from election considerations than members of council.
Yeah. I wanted to answer the question in the chat. This is going to be a little bit different for planning and zoning because of that quasi-judicial kind of hat that the zoning board wears. But it's really, so there's going to be two different types of testimony. There's going to be expert testimony, which is somebody who's qualified as an expert before that board and has some qualifying experience that makes them that expert. And then there is layperson testimony. So there's neighborhood, there's the people who live in the area. There's the people who drive by it every day. There's the people who grew up over there. They may not live there anymore, but they have some kind of firsthand knowledge of the circumstances surrounding, the particular application. Both of those are useful testimony for a board member or a commission member. The question then becomes, what weight do you give their evidence? So what weight do I give to an expert as opposed to the weight that I give to somebody who may not have expert knowledge, but has firsthand knowledge of living there, walking there, working there? And that's really up to the members themselves to kind of make that distinction. do I give more weight to an expert? Typically that is the case. You give more weight to that expert. But it's not to say you discredit or discount the layperson. You just hold their testimony to a different level than you would to the expert testimony.
But it helps if they have photographic evidence.
Absolutely.
So, experts are often, they're looking at data and they're looking at historic patterns, but maybe they don't see that an area routinely has been flooding lately, right? Because of weather. Whereas people who live there can take photographic evidence and say, look, this street floods and it floods frequently. I have the evidence. And especially if they show up in numbers. Another issue might be traffic. Traffic is often one where the expert might say that, this intersection is perfectly safe, but the people who live there say, no, there's a preschool over here and there's elderly over here and people never cross at the crosswalk. And so they can talk about the reality of the situation, and that's important for boards to hear. So, I don't know that that follows a strict term of evidence, but it's definitely persuasive when used effectively. All right.
We are actually 15 minutes over, so I think we agreed we'd stay on for any questions until 7 o'clock if anyone has them, but anyone obviously who wants to jump off, we are over time. And I want to thank everyone for coming. And also,
I'm happy to stick around for 10 minutes if there are more questions.
I wanted to thank GrowSmart and the consultants for presenting what I thought was a really great presentation on the process in a very short period of time, very concise.
Well, thanks. And I want to thank the Caroline and Ashley as well for doing an excellent job and for their public service and their service in getting the public more engaged in this important process.
Do we have any other questions?
I see one. Will this be on your website?
Do you know, Alex?
Yeah,
Will you do
we'll
that?
set it up as like a YouTube link or something to that effect.
It has been recorded.
Yes.
And I know there was an interest in getting the PowerPoint presentations, and I guess between ALT and GrowSmart Rhode Island, we figure that out, right?
Yes.
Get that
We
out.
will get those to people as well.
Yeah.
Why, do we have web? We don't have emails, so they'll be posted on the website.
Right.
Well, thank you everyone for coming.
Thanks, folks.
And we have another presentation coming up August 31st with the city of Newport.
Hey, Chuck, do you maybe want to mention that the last session, which would apply to
Yes.
the folks listening tonight, as well as the other communities on the island?
Yeah, so the last session will be a more advanced session beyond these kind of introductory level issues. And that will be open to all 3 communities. So, and that's October 20th. So if you are interested, we will have a registration similar to the one we had for tonight's workshop.
Well, have a good evening, everyone.
Well,
Good
thank
night,
you.
everyone.
Thank you,
night.
everybody. Take care.
Bye.